Hello and welcome to the Readout's Regulatory Roundup, where we'll be discussing matters affecting the health and social care sector, discuss how this could impact you as a provider, and offer you some insights in how to minimise risks to your business. My name is Caroline Barker and I'm a Director and Non-Practicing Solicitor at Readouts. Today I am joined by my colleague Samantha Burgess. Samantha is a Senior Associate Solicitor at the firm and has been with us for 9 years now, so she has a lot of experience working on the types of cases that we're going to be discussing today. This is where CQC or Ofsted have issued a document called a Notice of Proposal or a Notice of Decision. Now, that might be a term that some of you are not familiar with, and although we are dealing with that day-to-day frequently, it's not something that providers have necessarily come across yet. But the consequences of receiving this document can be extremely damaging to a provider's business and sometimes ultimately can close a business down. So it's probably worth going back to basics. Sam, could you explain to people what a notice of proposal and what a notice of decision is, please?
Hello, yeah, sure, happy to do that. Well, in an enforcement context, notice of proposal and notices of decision letters, and I'll refer to them as NOPs and NODs from now on, just so it's not so wordy. They represent action at the higher end of the CQC's enforcement capabilities. The CQC's power to issue NOPs and NODs is conferred through the Health and Social Care Act, and the types of action that can be taken include cancellation of registration, changes to conditions of registration, which would include variation, imposition, or removal of them, and suspension of registration or extension of a period of suspension. And NOPs and NODs represent different stages along the enforcement process. So firstly, at the NOP stage, that's a proposal stage, the action stated in the letter is simply a proposal. It doesn't represent definitive action and so won't take effect, if at all, until the final outcome of the matter is known. And there's plenty of scope along the way to persuade the CQC that the action isn't required. Now, in terms of NODs, well, there's two types of NOD. So the first falls under what I refer to as the normal process. It will follow a NOP if a provider's representations have been unsuccessful or they haven't submitted representations. There's a fairly low threshold legal test that the CQC has to satisfy to justify taking the action, and that is that the proposal is being made on the grounds that the regulated activity is being or has at any time been carried on otherwise than in accordance with the relevant requirements. And those would be the regulations that providers are required to comply with. So, for example, regulated activity regulations or the registration regulations. Again, this type of NOD, the normal process NOD, doesn't take effect until a final decision is made on the matter or the provider fails to submit an appeal. Now, the second type of NOD is referred to as an urgent NOD, and this represents the most serious action the CQC can take. So urgent NODs take effect immediately, and they follow an expedited appeals process through the first tier tribunal. They're served under sections 30 and 31 of the Health and Social Care Act, and the legal test for these has a higher bar than that normal process NOD. So for a cancellation NOD, the legal test would be that it appears to the justice that unless an order is made to cancel the provider's registration, there will be a serious risk to a person's life, health, or well-being. The other type of urgent NOD to, say, vary, remove, or impose conditions or to suspend registration, the legal test is that if the Commission has reasonable cause to believe that unless it acts under this section, any person will or may be exposed to the risk of harm. And in terms of this urgent action, CQC may issue a letter of intent in advance of an urgent NOD, so providers may have some warning. And usually these letters of intent require a response within between, let's say, 15 hours to 2 days. It's normally the normal range for responding to those if it's received. But that's the different types of NOPs and NODs that you might come across.
Okay, so it's pretty wide-ranging, the types of action that CQC can take. So if a provider receives a notice of proposal, because from what you're saying, that's the first stage well, one of the first stages that CQC can take, what should a provider do? You know, how should they respond to a notice of proposal?
Yeah, so first thing to remember, and the notice of proposal, the NOP will say this as well, that is that a provider has 28 days from the date of receipt to submit of the NOP to submit representations to the CQC. If they fail to submit representations, a NOD will automatically be issued. In terms of how to respond to them, they should consider carefully how they intend to approach the representations. And I'd always recommend that they seek legal advice at this stage. The CQC is required to set out its reasons for taking the proposed action. And depending on the fact of the case, the types of things that may be put forward in representations are points of factual inaccuracy. You might be challenging the proportionality of the proposed action, or providers might be detailing improvements that have been made since the concerns were apparent. It's really important to appreciate that any final decision made by the CQC or a subsequent tribunal panel must be based on the facts of the case at the date of the decision. So this means that any action taken by a provider to address concerns raised have to be considered. It's usually expected that the CQC would carry out a re-inspection of a service following receipt of a NOP, representations to assure itself of the position of the service at the time of making its decision. However, this isn't a given. The CQC has been known to issue NODs without re-inspecting and raising concerns which could have easily been clarified upon inspection. This type of action is, we would argue, is premature and exposes the CQC to additional challenge through the appeals process.
Okay, so you mentioned a variety of types of notice proposals. So you mentioned cancellations and variation of conditions. What sort of variation of conditions can CQC impose or want to impose on a provider?
Yeah, so the usual ones we see would be there could be a restriction on admissions put in the provider's registration. So usually that's they cannot admit any service users to a service without getting the prior written agreement of the CQC. Other ones we've seen are requirements for sending information to the CQC. So maybe monthly action plans or details of how audits are being carried out at the service. So that type of thing.
Okay, and can talk about cancellation notice proposals. Is that the same in terms of when a provider has several homes on their registration, or you're varying the conditions to remove a location? Is that correct?
Yeah, so a cancellation notice proposal, yes, would be in relation to the whole registration, whether they have a single location or multiple locations. Whereas if the CQC had a concern about an individual location, they might apply to remove a condition of registration where a specific location is being carried out. So basically, that's very similar to a cancellation in terms of closure of that service, but it's just done under the conditions process rather than outright cancellation, which is the actual registration.
So individual homes can essentially be closed down by CQC. Okay.
Yeah.
So assuming that a provider has put together representations to a notice proposal, which we hope they would, and they've submitted those, you've obviously said CQC sometimes don't come back to re-inspect, which is slightly concerning. But the next stage would be a notice of decision then, would it? So maybe talk a little bit about what happens when a provider receives the subsequent notice of decision.
Yeah, so if a NOD is received, then the provider has another 28 days from the date of receipt of that NOD to submit an appeal to the first tier tribunal. So this is this first stage where the decision making is taken outside of the CQC. It's the first tier tribunal is an independent body completely separate from the CQC that is then given the power to make a decision on the appeal. The only real difference in terms of normal process nods and urgent nods is that with an urgent nod, the provider must comply with the action set out in the nod immediately. Whereas, as I said earlier, if it's a slow, normal process nod, then that action still doesn't take effect until there's a final decision. And if a nod isn't appealed, then the decision will take effect.
Mm-hmm. Okay, so you said that under an urgent nod, the action takes effect immediately. So I guess can CQC immediately close down a home?
So they can, in terms of cancellation
Mm-hmm.
and an urgent nod, the CQC has to apply to a justice of the peace, which is the magistrate's court, in advance of a cancellation of a full registration. And so then there's a very fast process where the magistrate's court would hear evidence from either side to determine whether they are going to validate that nod. Whereas in terms of the other types of urgent nods that aren't cancellation linked, so under Section 31, the CQC can issue that immediately without having to apply to the courts first. And that can include if they're removing a location from a condition of registration. So that would cause closure of the service, an individual service, immediately without that prior clarification from the courts.
Okay, so but there is an appeal process to that. So how long would that, you've mentioned appeal process being speeded up, you've talked about expedited appeal processes. How long would an appeal process typically take?
So under the expedited process, you still have 28 days to submit your initial appeal. Once that appeal is submitted, there's approximately a 3 to 4 week window where everything happens very quickly. The CQC has 3 working days to respond to the appeal once the tribunal has sent it to them. And then after that, there'll be a telephone case management hearing where we have all the evidence exchange, dates for that agreed, and they'll set a court date for the final decision to be made. So it's, as I say, it usually takes within 3 to 4 weeks of submitting the appeal for you to get a final decision on that matter. And the reason for that is because it's recognised that this type of urgent action can have a massive impact on both providers, businesses, and on service users. And so it's important that it gets dealt with very promptly.
Okay, then that's under the expedited process. How long would an appeal process normally take under a normal NOP NOD process?
Yeah, so under the normal process, again, you have 28 days to appeal. Once that's submitted, the CQC has 20 working days to respond. And then it really depends on availability of witnesses, on availability of legal representation and the tribunal as well, as to how long that actually takes. But normally, from the date of submission of an appeal, if the CQC is opposing it, we'd expect you to be in front of a tribunal within about 3 to 5 months. But that will also be dependent on whether there's any stays in proceedings along the way. So a stay is a pause in the process to allow something specific to happen. Usually that would be for the CQC to carry out a re-inspection to assess quality, so they have a better appreciation of the strength of their case. So if there's not a stay, I'd say 3 to 5 months. Otherwise, it could take as long as it takes.
Right, and is it always a foregone conclusion that you would get to the first tier tribunal appeal stage, or are there opportunities to kind of head off the action before then?
Yeah, not at all. Definitely the opportunity to negotiate along the way. The vast majority of appeals that we work on at Ridout don't make it to a final hearing because it's been resolved prior to that point. So there's still lots of opportunities to resolve that process.
Okay, and if for any reason you can't resolve it ahead of getting to a final appeal hearing, what are the types of outcomes that a tribunal can come up with?
Yeah, so the tribunal have wide-ranging powers. So they can allow the appeal, which means that the provider wins and the action goes away. They can dismiss an appeal, which means that the CQC wins, the decision takes effect or continues to take effect in the case of urgent nods, or the tribunal can vary, remove, or impose any discretionary conditions of registration that it sees fit. And we were kind of talking about the final hearing process here, but the tribunal can do any of these actions at any point along the appeals process. And as I said, they can also stay an appeal as well, which means that the proceedings are paused. Yeah, and those are the main powers that the tribunal has.
Okay, so there's a lot of process involved in start to finish, really, which I guess that's why providers get lawyers involved, because they can actually help them along the way in terms of navigating the difficulties of these quite complex proceedings. Are there any other matters that providers should consider more generally if they receive a notice of proposal or a notice of decision from the CQC or indeed Ofsted?
Yeah, so providers should be aware that the CQC or Ofsted are likely to notify any relevant local authority of a NOP or a NOD, particularly if they relate to cancellation or if there's imposition of conditions of registration restricting admissions, although that's only in relation to the that's the CQC's power. They'll tell the local authority if they are have a placing arrangements with the service so that they know not to refer. So therefore, providers may need to additionally manage the relationship with a local authority, providing reassurance to commissioners as to what they're doing, what their case is, and how they're addressing potential accepted concerns. Some local authorities, especially in terms of cancellation nods, can get nervous and may seek assurances that an appeal will be submitted, because obviously if a provider doesn't appeal, then that decision takes effect. So they'd have to move very fast in terms of moving service users out. So you might have to do some relationship management there with the local authority. Other parties to consider are, well, what, if anything, the provider will be communicating with staff, residents, and relatives. Matters can snowball, and if communications aren't managed appropriately, that can cause issues down the line. Another thing that they can consider is if a provider has recognised that improvements are required, these should be actioned promptly. And some providers, especially those without internal quality assurance teams in place, could benefit from having an external consultant involved to assist the management team in making changes and reviewing quality and improving, and to demonstrate that they're taking these matters seriously. But the biggest thing I would always advise is to seek legal advice when you're entering into these processes. The CQC will have solicitors and barristers working on their behalf, and providers should also. This is a legal process, and you need to understand the legal side of this in order to put your case forwards properly and to help you get towards a positive outcome through the process.
Okay, so there is opportunity to make improvements. It's not say a foregone conclusion. That people can improve, and I think you mentioned earlier, Sam, around making a decision, the tribunal or CQC at the nod stage making a decision about the service at the time the decision is taken, so that there is opportunity for people to improve and demonstrate that they've made changes to the service.
Yes, definitely.
Okay, brilliant. Well, there's a lot for providers to take in there, and we hope today's session has been useful to help you understand some of the basics of this really quite serious enforcement action. You can find more information and resources on our website, www.ridout-law.com. And if you ever find yourself on the receiving end of this type of action, then please do not hesitate to reach out to the Ridouts team, who will be happy to help you. Thank you very much.
Thank you.